Hi, everybody. I'm just going to give it 5 more minutes before we go live, right? So we'll start at 10:05. Just there are probably a few people that stuck at the bottom, so just give it an additional 5 minutes before we start. morning, everybody, and welcome to CiTi and BioCiTi, to this, what I view as an incredibly important community event on intellectual property. So for those of you who don't know, CiTi is the Cape Innovation and Technology Initiative. It's known as the oldest tech incubator in Africa, and have made significant inputs into the growth of the Western Cape economy. And on the back of that success, CiTi identified biotechnology as a major emerging area and a contributor to the South African economy, and therefore in 2019 created BioCiTi as a biotech-specific business incubator. So BioCiTi incubates biotechnology businesses or businesses responding to the bioeconomy, and we have our own laboratory that we make available on a rental basis to the various startups and SMMEs that need access to it. Being active in this space, both CiTi and BioCiTi have realized the importance of intellectual property, especially for startups and SMMEs that work or want to translate intellectual property into business concepts and commercial realities. So on the back of that, we conceptualized this event to try and put out information, educate people within the ecosystem on what intellectual property is, because we understand that all startups have intellectual property in some way or the other. So hopefully this event is gonna shed some light on what is intellectual property, how to manage it, how to protect it, and we have a healthy discussion and networking around the topic. So Von Seidels is a patent attorney firm that has partnered with CiTi and BioCiTi to help us get this message of intellectual property across, as well as Mr. Fani Murray, who's a serial entrepreneur and an IP practitioner for many years. So our program for today is we got Mr. Rory Moore, who's a patent attorney at Von Seidels, and his background is in life sciences and chemistry, as well as a law degree, and he's worked in public sector and academia for 25 years in the tech transfer space. Von Seidels is an intellectual property law firm specializing in patents, trademarks, copyrights, design, trade secrets, licensing, and related areas of IP throughout Africa. They're based in Cape Town, South Africa, as well as regional offices in Namibia and Cameroon and Nigeria. So the other two speakers that we have on the program is Mr. Fani Murray, who's a science and business professional. He's a director in I think 5 different companies that he's applied intellectual property in various different forms and taken them to the market. He's worked in the biotech space and intellectual property management for over 30 years. And his experiences in aiding science-based organizations manage their intellectual property is what we're hoping we're going to share. So I think between Rory and Fani, you've got a good set of speakers that's going to impart knowledge into you, and hopefully the panel discussion that's going to be led by Brendan Hughes. So Brendan is a legal professional and a technology entrepreneur with an LLB degree from University of Cape Town. He has more than 15 years of experience working with technology startups. Brendan currently serves as the chairperson of Ingenie EdTech Ventures, Africa's leading EdTech incubator, investing in EdTech startups across the African continent, and as a director of BioCiTi and Biotechnology Labs. He's the co-founder of LexVision Group, an international group of companies licensing and supporting legal industry technology solutions, including sharebrief.com, mediabrief.co.uk, and lexventures.com. Brendan also serves on the board of CiTi and on the advisory board of the University of Cape Town law faculty. So Brendan is also director of CiTi's impact investment wing, and he will give a little more background on that when he starts up the panel discussion. So I'm not going to take up more time, and I'm going to pass over to Rory, who's going to take us through his presentation.
Good morning, everyone. It's great to be at this venue. Beautiful view of the mountain. I'm, as Deepak said, Rory. I'm from Von Seidel's Intellectual Property Attorneys. We're based in Cape Town. I'll be talking about intellectual property and overview, and then I'll be looking at the business context of IP, how to protect it, the uses of it. Then, if we have time, I would like to address some of the biotech aspects of intellectual property. So, there are some of my colleagues here, Rechard, I see. So if you have interest in other fields, mine is chemistry, biotech, life sciences, but we do have other expertise here if you'd like to talk to the people. So, kicking off, the main focus is intellectual property for entrepreneurs. As I say. So there's several categories of IP. You can see them there. The main ones: patents, trademarks, designs, copyright, trade secrets and confidential information, and personality rights. So we'll go through those one at a time and see what the requirements are. What are patents? A patent is a government-issued certificate giving an exclusive right for an invention, normally 20 years of monopoly. It's what they call a negative right, so it gives you the right to exclude others from practicing or the invention, so making, using, selling the invention. To qualify to be patentable, an invention must be new and inventive. Can be a product, process, devices, their compounds, computer-implemented inventions, computer-implemented systems. But most importantly, it must be new and inventive, which means not obvious to persons that are skilled in that field. The novelty must be absolute, so that means that it must never have been done anywhere in the world before, and never have been made available to the public anywhere. As I said, to be inventive, it mustn't be obvious to persons skilled in the art, in that field, and experimental evidence can often help to show that an invention is inventive. But also, if it's a solution to a problem, then it's also a good indicator that it's an invention. So Abraham Lincoln said that the patent system adds the fuel of interest to the fire of genius, which is a good description. So it motivates invention. Generally, the route to obtaining patent protection is that you would file a provisional patent application. That will give you a year of protection. You need to do it before the invention is made public. And then once you've filed the patent application, you can then disclose to the public. It's valid for 12 months. And then you would need to decide if you want to continue with the patent program overseas in South Africa as well. And the timeline to grant for a patent can be 18 months to 5 years, 5 years, say, in the US or Europe. Okay, then turning to trademarks. A trademark is a unique mark that distinguishes a trader's goods or services from those of its competitors. So it protects distinguishing signs. The trademark rights can be registered or unregistered, but there are benefits to actually registering a trademark. And they are assets to a business, but they are also important to stop confusion on the part of the consumer. the indicators of origin, and they can be in many different forms: trade names, logos, slogans, any kind of stylistic representation, sounds, patterns, shapes, the general look and feel of a product or service, how it's marketed. They must be capable of distinguishing, so they mustn't be descriptive, and they mustn't be similar to earlier trademarks. Registered designs, a design relates to the appearance or shape of a product rather than patent, which relates to the concept. So a patent would relate to the way something's made or how it works, whereas a design is restricted to the appearance of an object. Designs to qualify to be registrable, they must be original and not commonplace. It's a low-cost form of protection. It stops actual copying of your product. So it's worth looking at, and you can use designs in combination with patents, so it's worth looking at both. They're easily enforceable. In South Africa, you get two different types of designs. You get an aesthetic design, which is for features that appeal to the eye. That has a 15-year term. And then a functional design, which relates to function, so the features of the design are necessitated by the function. That lasts for 10 years. Copyright, that addresses copying. It's typically it protects many aspects. It protects literary works, artworks, could protect advertising jingles, website content, but it's a narrow form of protection, so it specifically to infringe it, you require that the person actually copied your material. Trade secrets, this is very important actually. It's often overlooked, but you have know-how, you have trade secrets, you have ways of doing things that are not known to your competitors. And that's also intellectual property. It must be kept secret. If you disclose it, it becomes part of the public domain, so then it's not protected. And this is the kind of information you would protect with non-disclosure agreements, with contracts, employment contracts. So it might relate to formulae, ways of doing something, processes, recipes, and so on. Personality rights I won't touch on too much, but it's, say we're a celebrity, we all have a right to identity, to privacy, to dignity. So a celebrity can't just have their face put onto a keyring, for example, without their permission. There's one other form I should mention of IP, and that is plant breeders' rights. That's to protect new varieties of plants. But I won't go into too much detail there. On the business front, IP assets are very valuable to small businesses. As you can see there, they underpin the competitive advantage of the business. They allow the business to prevent or exclude or deter others from entering the same space, and of course they can be monetized. So just looking at an example, I'm taking the Coca-Cola constellation of IP. So on that page there, we have different aspects which could be protected by different aspects of IP, as we've discussed. So we have there a trade secret, we have an appearance of an article, we have a trademark, and we have something that could be protected by patents. So let's start with the Coca-Cola name and label, logo at the bottom there. What would that be protected for? Anyone? What would that be protected by? What form of IP? Trademarks, yeah, that's right. And then looking at the can on the left, that's to do with the pull tag. You remember in the past, the pull tabs on cans, you used to pull them off and throw them away. Then they developed this one that doesn't come off. So what could you protect that with? It's a general concept rather than the appearance of something. Yeah, so that would be something you could protect with a patent. Then we have apparently the original recipe for Coca-Cola in the book there, dates from the 1800s. We don't know if that's true, but so what kind of IP would that be? Yeah, so that's trade secrets or confidential information, and it's never been disclosed. The advantage of it is that if you can keep it secret for 100 years, as Coke has done, then you have protection for 100 years, whereas patents only last for 20 years. And apparently the directors of Coke, they never fly on the same plane together in case they all die at once and take the secret with them. And then the last, the picture on the right there, that's of the shape of the original Coca-Cola bottle. What would that be? Anyone? That's to do with the appearance of something, as opposed to the way it's made or the way it functions. Okay, so that would be protected by registered designs. As I said, design relates to the appearance of an object, of a product. So that's just to give you an idea of how the different categories split up. Sorry, I keep pushing the wrong way. So why would a business obtain IP protection? It has many advantages. So it can stop or deter competitors, a shield, as we mentioned. You can license others, so you get income for others using your technology. You can attract investors. This can be for grants, for example, from the government, from TIA, can be venture capital investment, can be loans. But the advantage is it's a kind of credibility. It gives you credibility, puts a stamp of approval on your business. And it allows you to negotiate with third parties. It's a bargaining chip as well, the IP. Yeah, that's basically just a refresh on what I said before, the credibility aspect. It also allows you to market and pitch. You can put your IP registration numbers on your websites, on your products, and there's benefit in that. And then, of course, you can monetize. You can monetize, turn the invention into a tradable commodity. That's just a graph which shows that the intangible assets of businesses have grown over the years and are now estimated at over 80% of a business's market capital. Something you should look at as a small business getting into starting up is doing a freedom to operate search. This is where you would look at the landscape in your industry, see what patents are in place, where you can operate and where you can't. That a patent attorney could assist you with. So that's third-party IP rights. Sometimes it's easy to establish where patents lie, for example, with pharmaceuticals, with chemical compounds, but sometimes with systems, for example, software tech, with algorithms, quite difficult to work out who has protection for what. But patent attorneys can assist you with that. Even if there is a risk, FTO, risk, freedom to operate risk, should weigh it up with the benefits of entering the space. So just as an example, Napster, there was copyright infringement and they were shut down, but YouTube was doing the same thing, but they moved rapidly. They got snapped up by Google for 1.65 billion. So that's another way to look at this situation. Even though freedom to operate may be an issue, it's not always necessary to back off. Again, patent attorneys could look at that for you. So the monetizing aspect of IP, the IP underpins the value within a business, especially today, as I said, with the intangibles. Intangibles being another word for intellectual property. With them forming such a large part of the capital of a business. In many countries, IP which is developed by a company is not or does not have to be reflected on the balance sheet, only IP which is acquired. So as a result, business owners, directors, executives, they tend to overlook their own IP. And so that it's worth being alive to the fact that you need to examine what IP you have. It's very valuable, and there are different ways in which you can do that. You could carry out an IP audit. So audit here just meaning a check of what IP you have in-house. And this can just be confidential information, trade secrets. Doesn't necessarily have to be registered patents and so on. So even as you're walking around your laboratories, your factories, talking to your staff, just ask them, is there anything clever, new that's happening? And then make a record of it. Keep it in a register, your own register, of what IP is in the business. Also, you can get IP due diligence investigations carried out. So TIA, for example, Technology Innovation Agency, if they're going to give a grant, they will send their own people, and I used to do this, to go and check what IP is in place in the business. And that serves as collateral or a basis for the funding. So it's very important. So it's worth keeping track of what you consider to be your own IP. You can also get your IP valued, and there are various different ways in which this is done. And it's good to get a value on your IP for various reasons, especially if you're dealing with third parties. So IP valuations can support fundraising activities. IP is collateral, so it helps to put a figure on what it's worth. Also to support investment decisions amongst the business owners. Where should we take the business if we know the value of the IP? So a very common way of monetizing IP assets is via licensing. So I'll just look at that briefly. A license grants permission to do or use an asset, e.g., for example, an IP asset, under certain obligations and conditions of the licensee. The licensor is the party granting the license. The licensee is the party which receives the grant of the license and is subsequently the holder of the license. So there's no transfer of ownership from, say, the patentee to the licensee. The licensor remains the owner, but then there are certain rights which the licensee gets to exploit the invention, and there are certain obligations which the licensee has. So a license doesn't have to give a full right to exploit the entire invention. It can have conditions, it can be restrained or constrained in various ways. So you can limit it with regard to the territory that the license applies to, say just South Africa, for example, or the global. You can set targets or key performance indicators, milestones that have to be met by the licensee, otherwise the license expires. You can specify the field in which it can be used, the technical field. You can specify whether the licensee is entitled to sub-license to other licensees. The duration, whether the license can be renewed. So all of these are negotiable. It's a contract, so you can negotiate with your licensee. You don't need to give away all your rights. You can give an exclusive license but still remain able as the patent owner to also exploit the invention. Non-disclosure agreements, you're probably all aware of, very important. If you're going to disclose information before you've got a patent or registered design, put these in place. There are limitations to them, but it's a contractual obligation on the other party not to disclose the information. And you have a contractual remedy then if the information is disclosed. I recently had a new client that came to me. They developed an invention. They spoke to a product developer in the UK to exploit it. This product developer put time and effort in, but they just added a few bells and whistles, and they went ahead and filed a patent application in the UK without consulting or mentioning it to the inventor. And now the inventor can't even get a copy of the patent out of them, patent application. And they know as well that they haven't been cited, the client hasn't been cited as an inventor on the patent application. So these things happen, misappropriation of invention. So it's worth also with your NDA, if you can, put a clause in there or at least get in writing in an email that no patent applications or design applications will be filed without consultation and approval from yourself. And you can also mention, get it in writing, that if applications are filed, that you will be cited as an inventor. I just wanted to chat a bit about working in my field. Often you'll meet people in public and they find out you're a patent attorney, and then they'll ask you, you know, what's the most amazing invention you've ever handled? And I always say, you know what the amazing inventions are. Patent attorneys are just 18 months ahead of the curve. Patents get published, or patent applications get published after 18 months. You know, the public would hear about it in the news, or they would see the product commercialized. But the problem is, people, and it applies to all of us, we start taking tech for granted. So I was chatting to someone recently, and he said, you know, he said, what's the most amazing invention that you've ever seen? And then he sort of answered his own question, and he said, there's been nothing really in the 21st century. For 20 years, we've had no inventions. And I was kind of stunned because, you know, apart from the fact that Elon Musk is landing orbital class rockets, which 10 years ago we didn't even have, we've got electric cars, we've got this mRNA vaccine, we've got artificial intelligence, and cell phones, you know, our smartphones. I remember when I was at school, if say my mom forgot to pick me up from school, and I would have to walk to town and find a payphone to try and call her. Video cameras, we would walk around with a battery pack hanging off your shoulder, huge thing sitting on your shoulder. If I had to do a project at school, I would go to a library in town and look at the Encyclopedia Britannica. It was normally about 10 years out of date. And an interesting story, my cousin who went as an exchange student to America, the only way she could communicate with her parents was to record a message on a cassette tape and post it to her parents in South Africa. So all of that now is in a smartphone, all that function. And it kind of makes us cyborgs, you know, augmented humans. Because we have access to all the world's knowledge. We have access to a network of people anywhere in the world on demand. So that brings me back to the point. People start taking tech for granted. And then the point that follows on from that is that if you don't need an earth-shattering, groundbreaking invention to patent it. Again, it's if the IP is new, if the invention is new, and it's not obvious. So if you have an argument that it's not obvious, then consider patents, consider designs. Because it is kind of incremental. After a while, we realize what progress we've made, and it's certainly, as we said there, it's so beneficial to your small business, your company, to protect your IP. So don't overlook it. Don't overlook, do your IP audit, realize the value of it. But just always be aware that if you disclose or you start marketing your invention, and you've not protected it, not filed a patent application, that IP goes into the public domain, and then you've lost the right to protect it. So I'll just talk a little bit about patenting in biotech. Biotech patents have been around since the 1800s. Louis Pasteur got a patent for removing pathogens from beer yeast. And the general rules, you can actually patent genetically modified plants and animals, but there are provisions in patent acts that stop patenting inventions which could encourage immoral or offensive behavior, so against public morals. So, you know, for example, it's highly unlikely anyone will ever get a patent for a human which has been genetically modified. You can't just patent varieties of plants and animals which have been bred or selected unless it's microbiological. So you can get patents for microorganisms. You can get patents for microbiological processes. But not for animals and plants which have been developed purely through biological means, so selection or evolution or breeding. You can patent bacteria, fungi, protozoa, viruses, microorganisms. You can patent them, but again, they must be new and not obvious. And also, you can patent methods of using naturally occurring microorganisms. So even though you've made no change to the microorganism, but if you can find a new use for them, then you can patent it. You can patent gene sequences, but the law on this varies. So, for example, in the US, you can't patent isolated or purified sequences, but in Europe you can. In many places there must be some change. It can't just be a sequence which exists, say, in the human genome, but there's been no change. It hasn't been isolated. So in some cases, if it's been isolated, that's fine. Otherwise, for example, if you take coding DNA, that has been changed because it only has the coding part, so that would be new. You could patent that. But there are different rules around the world. It's worth consulting your patent attorney on gene sequences. And then there are other ways in which you can claim protection for microbiology, even if there's nothing new about the organism. So you could claim a process of using the gene or the sequence instead of claiming the gene per se. There are various rules, say in the USA, if the process just involves a natural phenomenon, then you can't patent it. And then when you file patent applications for gene sequences, you have to submit the sequence. And if you just have one nucleotide out of place in your sequence, that can be fatal. So you have to be very careful to make sure your sequences are correct. You also sometimes, if there's a new microorganism, you would make a deposit. There are various places around the world where you can deposit microorganisms. So I think there are about 20 different places you can do that. Your patent attorney would assist you with that. So this is just, as I was saying, you need to submit sequence listings. If there are 10 or more bases, or there are more than 4 amino acids. And that's to allow the examiners to make their searches. And that's just some information on how you can develop your sequences. And there's a new software format that has to be used from this year. As I mentioned, genetically modified organisms are patentable in most countries, but the patent doesn't give the owner the right to use the GMOs. In other words, there may be other regulatory hurdles that have to be met before you can actually exploit the invention. Environmental regulations, for example. And that's just a picture of the goose that laid the golden egg, which would be a good genetically modified organism that you have. Another thing to bear in mind is South Africa has the Biodiversity Act, and that requires that you need to get a bioprospecting permit in certain cases if the invention is derived from an indigenous genetic resource or traditional knowledge. And then if that is the case, you also have to put in place a material transfer agreement, sometimes, the benefit sharing agreement with the community or the party who theoretically own or supplied the indigenous knowledge. And that's quite difficult because you have to first identify the community. So just keep in mind the bioprospecting permit that you may need. And then looking at patents in healthcare, pharmaceuticals, you can patent a pharmaceutical or a compound for use in a method of treating a disease, but you cannot patent a method of treatment per se. So that gives, for example, surgeons, doctors, free rein to apply the new techniques to their patients. It's a policy decision, really, to allow people to be treated. But pharmaceuticals, patentable. Medical devices, patentable. There's no problem with that. So what would be patentable? You can patent compounds, processes for manufacturing the compounds. Within the compounds, there are all sorts of subcategories, as long as they're new and inventive. So, for example, you could patent a new crystalline form of a compound or a new enantiomer. So if it's been isolated from a racemic mixture. And there are many different ways, compounds. You can patent new dosage forms, slow release, extended release, for example, as long as it's new and not obvious. And then you can also, if there is a compound which is known, you can still patent its use in medicine, and that's called a first medical use. So if a compound has never been known for use in medicine, you can get a patent for using it in medicine. It's also possible to obtain protection for second medical uses. So what we're looking at there is the blue pill. It's called sildenafil. It was originally developed for use in treating hypertension and cardiovascular problems. And then its second use was discovered. And in South Africa, theoretically, the understanding is, according to the Act, you can't patent a second medical use. So if a compound's been known for use in a particular medical application, then you can't patent it for a second application. But there is a way around this called the Swiss type claim, where what you do is you patent the use of the compound in the manufacture of a medicament for treating that disease. So you're not patenting the use of the compound for treating the disease directly. You're patenting the way in which you manufacture that compound, and that compound, in which you manufacture the medicament, and then that medicament is used to treat the particular disease. So the point is that just bear in mind, if you discover a new use of a known compound in medicine, there are ways to patent it. Yeah, so that's the end of my talk. Thank you very much. It's been great to be here. And if there are any questions, we can take them. I'll turn over to you then, Deepak.
Yeah, if there's any questions, Keenan, will you just tell us if there's any questions online? But you're welcome to ask questions.
Yes.
On the patent part, I mean, if you patent something, you have to have detailed descriptions and sketches and designs and whatever to be able to patent.
Yeah, absolutely. Yeah, the question was.
Sorry.
Yeah. Okay.
So if you, I mean, that becomes common knowledge for anybody to say. So you can patent something, and then the business in Russia takes it and copies your patent, and you can't fight it. The legalities and the fees to fight that is so huge. You're actually giving away your patent. Can you just explain that part to me and whether it's worth, doing the patent?
Yeah, so the question is, it's a concern about disclosing or giving away your invention by filing a patent. And it is true, yes, after 18 months your patent application becomes published. So you may prefer to, if you can, keep the information secret, as in the case of the Coca-Cola formula. The reason that it does publish is because a patent is unusual. It goes against competition, healthy competition between businesses. So it's an unusual right. The state awards it because you are teaching the world how to carry out an invention. And so therefore, because it's an unusual right, you do have that quid pro quo that you need to disclose the invention. But certainly if you are satisfied that you can keep the invention secret, that's the way to go, trade secret. But then you must be aware that if it is disclosed, you have no protection. So the patent system may not be the perfect, but it's currently the only way to gain protection if you need to disclose an invention, or if it can be reverse engineered easily. But you're right, it does have to be fully disclosed, and you can't hold back. You need to actually you need to set out, in many cases, the best way of performing the invention. So, yeah, thank you. Other questions?
Rory, we have a couple of questions online. And the first one is, when it comes to the production and such, when is my company or the organization required to pay reproduction fees in terms of intellectual property?
Reproduction fees, meaning?
So with regards to how do you protect or secure your IP in a gig economy?
In the what economy, sorry?
The gig economy.
Gig economy. Yeah, I mean, I'm not entirely sure what is meant there, but I mean, the general procedure, as I said, is if you have a new and inventive product process, then you would go to patent attorneys. And as I say, that's currently the best form of protection that you can obtain, unless you can keep it as a trade secret. But it's a pity that the person asking the question is not here to give more information on what they mean.
Okay, so can we move on to the second question?
Yes.
The second question is, what are the repercussions of not having a bioprospecting permit in place?
Yeah, well, then you're in contravention of the Act, and you will have that legal ramification. And in fact, when you file a patent application, there are forms which you have to fill in, and one of them, you have to actually state that the invention does not derive from an indigenous local resource or traditional knowledge. So if you tick that box and say the invention doesn't derive from that, you're actually committing fraud or misrepresentation on your patent application, and that can then be grounds for invalidating it. So it is important. And as I say, if it is from a local indigenous resource, you would need to put in place benefit sharing agreements. You need to go through that process. Otherwise, you're endangering your patent program. Okay. Yes?
This is very invaluable information. I'm just learning a lot. In the case of, let's say, the argument between the please call me inventor,
Yes.
McCarthy versus the employer Vodacom, you find the issue that he claims to have invented the product, but what kind of advice would you give to a person who sits in a company, invents something like he did, and then how do you like get it patented, or to go outside and get an attorney to say Vodacom keep it just like as he's doing now? And what confuses me more is that case has been to constitutional court.
Yes.
And then it comes back, attorneys are still arguing that now you must get this 5% of that, this and that. It would seem to me that there is no proper explanation of where the rights end.
Yeah.
Where he comes in and then the constitutional court pronounces on it, but it's still in the judicial system and people are still arguing. What is happening there?
Yeah. That's an unusual situation, and probably as an IP attorney, not the answer you'd want to hear. Actually, I heard yesterday that Makati had been awarded 5% of all call revenue, which is billions, that derive from that. But actually, if you look at it, it's an improper application of the law, specifically IP law. It's bad law, because the whole matter has been decided on the grounds of contract as opposed to intellectual property. Now, there are rules in place that if you are employed by someone, a company, and you develop a product in the course of your employment and it benefits the company, then by operation of law, the prima facie, the implication at first sight is that that IP belongs to the company. So this goes against the general mood about Makate, but that's the law, is that he, in IP law, the Vodacom should have been entitled. So, and then the general rule applies from there. So if you are in a company, you're acting in the course of your employment, course and scope, you develop something which benefits your company, I've got to hand it to Makate. He's gone the route, but generally that IP would belong to the company. So I had a friend that I studied chemistry with. She went and worked for a company, I won't mention the name, in the petrochemical industry, and she developed something which saved them hundreds of millions of dollars every year. And they gave her, I think, £100 as a reward for her work. But does that answer your question? Yeah. Anything else? Anyone else? Yes?
My name is Popagati. I'm a director of a company called Emakosini Ikemisi Yesintu. If I would translate it in English, it's a pharmaceutical company per se, but focusing on indigenous medicine. Right. So I'm a traditional healer by profession. I've been doing it for 10 years. So now I've invented this company, or I've got this company where I sell traditional medicine. It started just selling traditional medicine because it's known. We've got people knowing medicine and they will want it. So for me, it's harvesting, preparing it, grinding it, and packaging it. But right. Now I've got my own remedies for healing certain things. We deal with spiritual healing, which is something that I think it's not really known in the world or really tangible as other healing methods per se, because then it's someone say, how would you prove it? But with with doing it all the time and having to heal certain people and even myself healing, so it's from experience. So what I'm on about here is that I'm creating home remedies or remedies to heal certain things. So now, for me to patent, to have a patent licensing and fall under the pharmaceuticals, it's not easy. So I want to know, in terms of indigenous medicine, how can one go about patent licensing, or even, because it's things that have been there but not been in the public. But now we are saying, hey, we are here too, because we're not providing your paracetamols, but I'll be providing an indigenous plant and saying, if you drink this 1 teaspoon of this, your headaches will be gone. Or you're struggling from this, and it's ancient knowledge. So how do we patent it?
Yeah, well, that is the concern. The patent system only protects inventions which are not known to the public in any way. So if they're not confidential, they can't be patented. But this was the reason for the Biodiversity Act. And there's a general movement around the world to traditional knowledge protection. And that's why you have to go through this procedure of getting the bioprospecting permit, setting up a benefit sharing agreement with the community. But another thing to look at is, although you may be basing your product on a known remedy, there may be some aspect which you've added to it, an advancement somehow.
When I say known, I say maybe the raw material is known, but the mixing is not known, because we are doctors, we indigenous doctors, and with us all indigenous doctors, we've got different formulas of creating certain remedies. I might have, like now, make tea bags, herbal tea bags. With my herbal tea bags, I'm using different products. Probably they are known, but I've mixed different traditional medicine in those. For me, then they're treating more like certain things. So in our African culture, we've got this thing, aumbi wandawoni, even from all, meaning it's not dug from the same place. So I can dug wild dacha in Cape Town, but if I harvest it in Northwest, it's not the same. It's not the same potent as the one in the Western Cape, because obviously the soil is not the same, the nutrients are not the same. So we've got that aumbi wandawoni. So definitely there is a difference with my remedies, and it's secrets, it's trade secrets for me, because then that's ancient knowledge that you get from your ancestors, that, hey, mix this and this and you'll be able to do this. And so far that's what I've done. And now it's integrating the modern way and our traditional way, so that it's recognized in our shelves. Like, for me, if I want to give you something to bath, now I can give you something to bath included in a shower gel, something that you are aware, or you know that, oh, this is a soap, but this soap is now added with more contents in it to heal certain alignments that you are not aware, because we're dealing with mental illnesses, we're dealing with stress, with the whole lot of things. And also trying to supply peace in the world because of certain things maybe that are not recognized.
Yeah, so I mean the general rules apply. If you have something new and inventive, you can either patent it, or if you believe you can keep it secret, that's fine as well. Then you could keep it as a trade secret. If people can't analyze it, reverse engineer it, find out what you're doing, what's inside your product, then keep it. Then you could possibly rather keep it as a trade secret.
Thank you. Thank you. I think this was very informative and looking to do more, because one thing I've experienced is that for the 4 or 5 years that I've invented it, I did not register it. So I only registered my company last year. But the problem is that you'll find that you do something online. Next thing, someone has taken your pictures or taken your words and all that. Then they start advertising on their own pages or own sites. So, thank you.
There's just one thing I should point out. If you've been marketing your products already, then even though it's secret, you cannot get a patent for it, unfortunately. It's only for new products. So that's why Coca-Cola at this stage could not get a patent for their formula if they try now, because they've been marketing it for 100 years. So that's... trade secret, it's, if you can keep it secret, that's the way to go. Like Coke. Thank you. Anyone else?
So, Paul, maybe we can have that discussion with Rory a little bit later, but I'm sure some of Fani's presentation might touch on that, because at the CSR we worked with multiple cases similar to this. Not exactly the same, but he might be able to have some value. 1 second, Linky. We've got one question online, and then I'll pass on to Linky.
So the question is, are there any programs available which assist with patent registration, including other IP and prototyping?
Yeah, there are various government entities which can assist. TIA, Technology Innovation Agency, is one of them. The RDC, Industrial Development Corporation. And they do have programs to assist with product development. The Technology Innovation Agency has technology stations around the country where you can go, so in your particular field. So Durban has a composites technology station, and there you can get assistance with product development. So that's one option. But as I say, there are programs in place. TIA and RDC, that's one way to start. And then there are various companies, private companies, which will assist with that. But it is difficult when you're starting up. They call it the innovation chasm, that businesses fall down. So they develop innovation, but then to get it to market, to commercialize it, is difficult. So, but yeah, start with those government entities. There are various others, there are funding agencies that you can look at. Does that answer the question? Yeah.
Rory, just a question. If I want to apply for an international patent, for instance, there's also that 18-month period, right, where things get published.
Yeah.
And I choose my 10 countries, for instance, and is it then afterwards, after the 18 months period, can I, if I see that another country is starting to using, which it's not patented in, and they start to use this patent, can I then go and patent it in that country?
Unfortunately not. You're limited to the countries that you designate when you file your, when you go into what's called the national phase after that 18 months. It's actually 30 months because it's the provisional 12-month period, then it's another 18 months. But at the end of that, you have to select where you file, which national countries, and patents are territorial. So if you don't get a patent in China, you don't have rights there. You couldn't subsequently decide, oh, there's a problem here, I'm going to get protection. There are some countries, developing countries, they have what's called a confirmation system. So, for example, or a re-registration system. So once you've got a granted patent in the UK, you may be able to get a confirmation patent in Nepal, for example. But in the major industrial countries, yeah, unfortunately, that's the way it works. If you don't have a patent in a particular region, you don't have protection. Yeah.
Thanks. Rory, just one last question from my side on the back of that. My understanding is the South African Patent Office is not examined. So maybe you want to just explain the difference between a South African Patent Office and maybe a US Patent Office on how they examine patents.
Yeah. South Africa has a registration system, they call it, but there's no examination currently, but it's coming. Either this year or next year. The Patent Office have trained up examiners, over 20 of them, and they're starting with test cases examining. So we will have an examined patent soon. South Africa's system is not bad because you get a very quick grant, and some clients appreciate that. But the problem is the quality is not great because you could get a patent for the wheel in South Africa because it's not examined. It's just examined for formalities, formal requirements. But as I say, the substantive search and examination is coming. South Africa's view has always been to let the courts decide whether an invention is patentable. So the Patent Office would put the patent through, and then the courts will, if it comes to court, decide. So it's an inexpensive system compared to overseas systems. but it has its faults. But yeah, it's coming, search and examination.
Thanks so much, Rory,
No, you're welcome.
for a very insightful presentation. Yeah, we'll engage in the panel discussion a little later. I want to pass on to Fani. I've introduced him earlier, but Fani has worked in the science and technology space for many years. His background is in fine chemicals and biotechnology. He's helped with managing intellectual property at the CSR, and as well now in his multiple businesses. So Fani, when you're ready, you can just unmute and share your screen, and thank you.
Okay, I'm sharing my screen now. Hopefully you can see my presentation. I'm going to go to full screen. I trust you can see it. I'm going a bit blind once it's on.
Yes, we can see it, Fani.
Okay, perfect. Okay, so I'm going to give you a bit of a talk around IP protection from a practical perspective. Okay, I myself, first of all, I work for Moravia and I'm the CEO. It's a small company. It's a management consulting company. We assist small, medium enterprises in basically commercialization of your technology. We do IP evaluations, we do IP management and a few other things, and also raise money on the back of IP. But about myself, I mean, there's a lot of things. I'm going to go through all of it myself. I'm also a chemistry master student, organic chemistry. But more importantly, I managed at CSR Biosciences for over 15 years. I managed a portfolio of about 250 patents, biotech patents. Our annual budget at CSR was about 3 million rand per annum for patents alone. It's quite a costly thing. I was personally responsible for dealing with all the examination officers around the world and the inventors of the patents and trying to find patents, trying to get patents to grant and then commercialize these things, and also try and get a balance of income versus the expenditure on the patent portfolio. So my presentation is going to be primarily quite a, it's going to be a practical thing. So I agree with what Rory was saying up to now, that you must protect your inventions, okay? And there are many ways, and I think Rory touched on most of those, and those are the different ways that I can summarize for you, but I'm not going to go through that. I'm going to go through one by one from a practical point of view. I'm going to start with patenting, and I call it the money game. It's a bit controversial, but I believe that's what it is. And I'll tell you why. So I think Rory has touched on what a patent is, but I'm going to highlight a few items that I think are important. For example, a patent is an exclusive right, but in return for that right, you must fully disclose your invention to the public. That's called the enabling disclosure in the patent. That means you must give the full disclosure of what your invention is. It's very important to remember that part. The triad of approving a patent or granting a patent is it must be novel or new, it must be industrially useful, and the third one is it must be non-obvious or inventive. It means that anybody skilled in the art mustn't be able to automatically come to the same conclusion or the same outcome as you have done. So it must be somehow a surprising effect that you observe that somebody skilled in art won't get to. It's very important to understand that part as well. And many patents fall on that third aspect. And of course, Rory mentioned that as well. Patents are territorial. So you must file for a patent per territory. And if you don't file a patent in a territory, it is not covered there. And you cannot afterwards go and file. So you decide upfront which territories you want to file in, and you stick to those, okay? Very important, one invention, one patent, okay? You can't protect 4 or 5 aspects, or 4 inventions per patent is not possible. Okay, and I'll give you an example, a practical example that I've gone through, and many of those have happened over the years where scientists try to cover the whole knowledge in one patent. It's not going to happen. I'll give you an example just now. And then the other aspect is patents are very, very expensive, and it's typically 2 million rand per patent over the life of the patent, and maybe it's more now with the rand-dollar exchange. I'm talking about 2015. We typically worked at a 2 million rand per patent kind of per lifetime budget. Patents are examined, remember, and the important thing is if you file a patent and it's not granted for some reason or the other, it becomes public knowledge, and you've given away your knowledge free of charge, okay? And don't think if your patent gets granted in Europe, it will automatically get granted in the USA, China, and India. In fact, the chances of the patent being granted in the same way in those 4 countries are almost 0. So you may very well find you get a grant in Europe, a decline, and very definitely in China, you can have a very difficulty getting a patent in China. Then I can tell you now in India, similarly. So let me go through an example, okay? This is a lot of text. I'm not going to go through the text, but I want to show you this is a patent, one of our very first patents we filed in about 2002, 2003, a very important invention in our mind. We contracted some patent attorneys. I think we spent R250,000 in patenting fees. At the time, we filed 6 patents, six BioCiTi patents. And then we licensed this onto a company. Well, we actually assigned the patents to a company that went to the UK. This case, by the way, is essentially the reason for the creation of NIPMO and the IP Management Act, but let us get into that as well. So these patents were then assigned to the company, they moved to the UK, and they commercialized. Okay, now, the problem with this patent was after 5 years, there was a major milestone payment due to the CSR. We were not part of the litigation process, and after 5 years, the company decided to lapse the patents and give it all back to the CSR. Well, not lapse it, give it back to us to do what you want with it. Okay? At that point in time, we discovered a number of things. The patent was wrote, all 6 patents were drafted very broadly. Okay? You can see it lists about 24 genuses of a particular yeasts that made a particular compound. They listed about 95 different species that are capable of doing it. I mean, and so on and so on and so forth. It lists about, I think it's about 9 sequences of proteins that are capable of doing this particular transformation. The examiners literally told them, guys, you know, there's no unity of invention here. Remember, it's one invention, one patent. So please choose which genus, which sequence you want to patent. If you want to patent them all, we have to split the patent into several patents, and essentially, it will be more than 100 patents. Okay, and at a cost of R2 million a patent, you can see where this was going, 200 million rand or so, or more even. Of course, the CSR did the worst thing at the time, and we just lapsed all of them. And I'll get back to the patents just now. It's an example of how it was, in any case, useful, but I'll get back to this now. Litigation is the next thing, okay? If you have a patent strategy without a plan or a budget for litigation, it literally equals publishing your information and giving your trade secrets away for free. And I'm going to give you an example. We did some work. We did a license agreement, exclusive license agreement with a company in the US, multinational. At the same time, they contracted us to do work for them, to do multiple series of development work to create multiple patents on the same product, basically different ways of making the same product. Because they wanted to have a wall of patents around this IP, and they wanted to protect any competitor from ever getting close to making this compound. They told us confidentially at the time, they set aside about $50 million to patent aggressively to protect this particular novel sweetener it was. Simultaneously, they set aside about $80 million for litigation, more money than I actually put aside for the patenting strategy itself. Well, a major competitor did start litigation. It's a long story. And they finally settled for a JV. They didn't even go for the litigation. But let's put the final thing I want to say to you. You can spend 3 to 5 years in court if anybody challenges your patent, and it will cost you millions of dollars. Okay, so none of us really, as small companies, have the ability, and I don't even think universities have the appetite to really fight this kind of legal battles. Okay, so let's go on to the next thing. Is patenting worth it? Around 97% of all patents never recoup their cost of filing. This is the data from the internet. You know, you cannot argue, but it's basically, in my experience at the CSR, very much the same thing. About 50% of all patents expire prematurely, primarily because people don't pay the fees. Okay. Patents filed by universities and so forth, tech transfer offices around the world, less than 20% of tech transfer offices even break even on the patent filing cost, let alone make money out of it. If you plan to build a wall of intellectual property around your technology, think again. Most patents are written far too narrowly for that to be the case, okay? And unless you file a suite of patents, there's always a way of working around it, okay? And if you've been in the game, like I've been for many years, you can easily see the gaps, because remember, a patent is only granted on the claim side, okay? So people make the mistake of looking at a world patent, WO patent, looking at the claims, oh, they covered everything. But by the time the examination is done, the claims have been refined to what actually is allowable in the patent office. Okay, so initially the claims are very broad. If you look at the PCT patent or a WO patent, you find very broad claims. Okay, by the time it proceeds to a grant in Europe or in the USA, you'll see the claims are substantively different and very much narrower. Okay, because ultimately you'll get patent protection for one invention only, and if you had multiple inventions in your text, you won't get protection. So please, if you do look at patents, look at the final granted patents, not the PCT. However, let me go back positive now. Is patenting worth it? Yes. A patent is simply what I would call a ticket to the dance. It's a marketing tool, really. In other words, it gives you relevance and leverage. Okay, how much relevance and how much leverage is depending on how deep your pockets are. To be clear, it's not a mere possession of a patent that help you. It's the funds they raise. Okay, now the example I gave earlier on, it actually helped the company. They raised 10 million Canadian dollars on the back of that patent suite. The fact they use a strategy of postponing any kind of decisions on the patent. So every examination office action that came through, they ignored slightly, and even though they got negative, you get what was called the International Preliminary Report on Patentability, IPRP for short. The IPRP tells you whether you meet those 3 criteria of novelty, inventiveness, and usefulness. And in their case, they got time and time again from the European Patent Office, they got IPRPs that said, no, you are not meeting inventiveness, you have a unity of invention issues and so forth. They simply ignored most of those and took the view that they will defend those in the national phase once they file nationally. So that way they managed to get 5 years or so of really not getting any patent to a grant. What they've done at the same time, in that 5 years, they sort of pivoted their business around using a similar platform, but for a very different product that was not covered in the patent. So after 5 years, they literally returned the portfolio to the CSR and said, we will continue to commercialize the parallel thing, which is not in the patent portfolio. So you see what it does. It leverages some investment funding for you. And I think that's the way. So it tips the scales in your favor, okay, in a sense. And that's my personal opinion, and we can have a debate on that going forward, okay? So there are other ways to protect your IP cost effectively, and let me go through those. So if you want to go the patent route, a much better approach is the CSR, the universities, international institutions. I mean, I personally, one of my companies, we have a license from the University of Cambridge in the UK. We pay them an upfront fee. We pay them sort of annual royalties for a patent portfolio that they own. It's very beneficial to us. We have a non-exclusive right to it, but we have an exclusive right of distribution in certain territories in Africa. We pay them royalties on sales, so it's a low risk thing for us. They carry the patent costs. They do the litigation. They handle the patents. So we have a patent to our company's name, but it's not our patent, and we don't have to have this huge budget for defending it. Okay, we only have to, if we sell something, we pay them a royalty. Okay? So that's a very good way. So try to get exclusive rights if you can. It's always more expensive for particular territories, and that's the way to have a patent in your company, but without actually having the burden, as a small company, the burden to actually do the prosecution and litigation. That's the one part. A trade secret is a far better way, especially for small companies. Okay, but now there's things about trade secrets. So trade secrets are anything about manufacturing, industrial secrets, commercial secrets, sales methods, distribution methods, really raw material supply. Now there are many, many things that form part of a trade secret. It's really the whole thing that makes your business tick, okay? And contrary to patents, you can protect them without registration for unlimited period of time. Coca-Cola being the example, 100 years of a secret thing, okay, for example. But you see, now this is the issue. It must be secret, okay? It must have commercial value. Some people think their secrets they have secrets, but meanwhile, it's either in a public domain or it's well known or it's not really commercial value. So it doesn't have commercial value. And you have to take reasonable steps. And unfortunately, in the biotech community, people like to publish and talk at conferences and so on. So you have to make an active role or to try and keep it secret to the extent that you limit certain employees from knowing exactly all of the secrets that pertain to the process, for example, or the manufacturing that you are doing. Let me go on to the next one. So trade secrets, like I say, often it may be around manufacturing processes, for example. I always strongly advise against filing a patent on a process. Because once you file a process patent, I mean, if you file a patent, it must be a sort of a state of matter patent, something that's really a platform technology. But if you file a process patent, it's extremely difficult to police. Okay? Unless you're able to get yourself into the manufacturing site somewhere in China, where a guy has been copying your patent in their factory, and you can go in there and prove beyond a reasonable doubt they are copying your patent, which is almost always not possible. So to police a process patent is impossible. Whereas a trade secret, you can file a patent on a high-level platform, but the detailed manufacturing process must be trade secret, in my opinion. Okay, so, and you can actually, you always must find a way, even trade secrets, to find a way to prove that somebody has stolen your secret. People will tend to poach your employees, thinking that they will have the information in their heads. And there are examples of that where people do then prosecute. You know, I mean, there's the recent case with Coca-Cola. I think some Dr. Yu or whatever her name was actually literally downloading data from the Coca-Cola database onto external hard drives, packing out of Coca-Cola, then took employment, I think, with Eastman Chemical Company. It was around how tins are treated on the inside, I think it was. In 2021, she was found guilty in the US. It was claimed to be $120 million sort of like damage to Coca-Cola. I'm not sure if she was finally convicted. I think the case was carrying on in November 2021. By now, she may have been convicted. But I mean, you can see it's a serious thing for Coca-Cola, and that is literally theft of a trade secret. I mean, there are many, I'm not going to go through all of it, but you can see there are many lawsuits, 2 billion, 1 billion, and so on, for people that have been infringing trade secrets. Okay? The next thing is trademark. Trademark is, of course, being ability to patent something, to protect a distinguishing sign, either to your good, your company, or products that you're making. Okay, and I'm not going to go through all of this, but literally, you can either file, you also file it territorially, you can file it in South Africa, you can file it in every other country where you want it, or you can file, I think through the WIP, or I think it's called Madrid system, you can file a single application, get some 100 countries protection, okay? And that's basically one of the better ways of getting some sort of course, a trademark is in a specific class of goods, so it can be a chemical, a pharmaceutical, can be I don't know, it can be many things, okay? And you must choose which class you want protection. So one trademark can be filed in many classes, and every time you file in different classes, an additional cost. Trademarks are also 10 years, but you can renew it indefinitely thereafter, I think, with paying fees. Roy can correct me if I'm wrong, and you can cancel it if you don't use it. Okay, so trademarks, example, it can be words, combination of words, letters, numerals, drawings, symbols. It can even be a flavor or a fragrance, color shades used in your distinguishing features. You know, below are some trademarks. You can see Nike, for example, that little tick, well known. It's Nike, Mercedes-Benz. You know, just a logo. We know it's Mercedes-Benz. There's no words there, but in time to come, the little Playboy thing there. So those are the type of things that are trademarks, and they're very, 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 very valuable to people. I mean, for myself, my own company that I work with, I actually filed trademarks recently. They're very cheap. If you do it yourself through the CIPC system, I think it's 590 Rand a trademark. I think that's what it costs. You pay maybe 2,000 or 3,000 Rand for the graphic designer to design something unique for you. You must be sure that your trademark is distinguishable from any other mark out there. Otherwise, you won't even be granted even in South Africa. So you have to make sure that you have something unique. So it's always good to have a graphic designer doing something for you that are unique. In this case, it's a insect repellent that's very potent, natural insect repellent. Okay, we call it Nutebug. So we found the wordy one called Nutebug there. We did something graphic of the same kind of style, a bit of a drawing, Nutebug with a dead mosquito on top. You know, there's a few options. There's also this. There's another one in a different color scheme. There's one here that looks a bit like an Angry Bird type thing with a little. The product comes from citrus oils. So you get an angry orange, like killing a mozzie with some writing underneath there. And other Nike style, you have a little orange without the wording. You know, hopefully people will recognize it as being just the orange. You can have a dead bug by itself, you know, and so on. And of course, you must also trademark your company logo, your company name, and so on. Those are the sort of things, and that gives you at least some market positioning. If you're looking for a marketing tool, trademarking is the way to go, especially in the area of like cosmetics, for example. Cosmetics, I mean, branding is all of it. You know, you'll find Revlon have essentially the same cream in all of their products, but depending on the packaging, it's a glass bottle versus a plastic bottle, and branded differently, and the prices are hugely apart. So branding is essential, and you have to trademark it as well. Trademarks are very important. There are case studies. There's this company called Louis Vuitton Duck, a South Korean fried chicken restaurant. So you can have trademark fights across classes, you know. So Louis Vuitton, of course, the handbag guys, whatever they make, they didn't like the name Louis Vuitton Doc. And of course, the fried chicken restaurant also packages their chickens in product packaging that looked a bit like the Vuitton thing. And they actually got sued for it. So they thought they were clever. They changed the name from, instead of Louis Vuitton Doc, that Louis Vuitton Doc. But if you actually read the word, it still says Louis Vuitton Doc. And again, they got a fine for $14.5 million for non-compliance. So trademarks is a serious thing. You know, when McDonald's came back to South Africa, I know they came down hard on any fast food franchise with a golden arc of any kind or an M in the name and so on. So that's the way trademarks are. And if you build a good trademark, you have a good brand, and it's worth a lot of money. There are other ways to protect invention. I'm not really going to go through these, but I know we've had cases like that, plant breeders' rights, where through evolution and so on, you create maybe a drought-resistant sorghum or whatever it may be, or you know, those are ones we've never actually at CSR or in my lifetime ever filed anything like this. But I know that the ARC, the Coastal Research Council, do things like this, and you can do it for potatoes, for sweet potato, whatever. So cultivars that have a high nutrient content, you know, you can actually file those, and you get some trees, for example, you know. So there are many things like that, cat flowers and so on. Copyright, literally anything you write. It's a good idea to, whenever you do a presentation, to have a copyright lowered. If you have a document that you write, you know, copyright. So those are other ways. I want to talk a little bit about registered design. We've done a few of those also at CSR. Now, I think the example that already used of the Coca-Cola bottle is a good one. It's very clear. You walk on the shelf and you see a bottle that resembles the shape of a Coca-Cola bottle, and you can pursue it. But if you want to follow registered design, let's say for a bioreactor, okay, so there are two different designs. Okay, one is an aesthetic design, so I think that applies more to the Coca-Cola bottle, where it's like the way it looks. You know, you can see it. It's aesthetic, but it's also a functional design. Okay, so let's for example say a bioreactor, okay, which has a particular internal configuration that increases the mass transfer. Let's for example say, if you follow, we did one before for a microwave pasteurizer to pasteurize eggs. We had a patent filed. The patent was running out, and we thought of extending the patent by now filing. We can't extend the patent, but by filing it, by that time we've improved the actual machinery that did the pasteurization. The initial patent was around the pasteurization of eggs using microwaves. That's the principle. But that had to be translated into a machine that can do it properly. The machine was very difficult to build, and after many years of building it, we've got a very unique design out of it. And we found by that time the patent was already, I think, in its 11th year or so. So we thought by filing registered design, we can actually, but the problem with the registered design is you literally have to give away your exact design. Okay, so you do that, and then next thing you see a Chinese guy copying it exactly. And again, how do you, I'm just Chinese, I'm not going to be particular, but I mean, it could be that. So at the end of the day, we decided not to go for a registered design, and rather just to keep that design secret, okay? Because that is more powerful than actually having a form protection for it. That's my view. And I think that's basically, now I'm going to give you one conclusion in short, okay? And then we can discuss. So in my opinion, I think trade secrets for SMEs are the best, most affordable option, but you must learn how to keep things secret. And in the biotech community, I know for a fact it's a very difficult thing to do. Trademarks are affordable. It's applicable to certain areas. And I often get people in the cosmetic industry coming to me and say, listen, can I file a patent? And I say, please don't. You know, please don't. You know, I mean, you'll find that Revlon will file a patent on a particular ingredient that goes, it'll be a particular proprietary developed ingredient that goes into a cosmetic, okay? But you won't file a patent on a face cream, for example. Okay, trademarks, marketing, branding, that's the answer, okay? Patents are expensive, consider an exclusive license instead, but you can always leverage a patent for other things, fundraising and so forth, okay? You must protect your inventions. That's very important. Otherwise, you have nothing. If it's common knowledge and can be commonly copied, you have no value in your business. And I'm just going to conclude by saying, be original, keep innovating, and don't only rely on patents to protect you. There are many other levels of protection. I know Deepak said I will touch on indigenous knowledge. I've been quite involved in that at CSR. You know, and what we tend to have done there is to actually, you can't really patent the plants or the extracts of the plant, but what we have done is to identify the active ingredients within the plant that are doing that are doing the job, actually proving that I scientifically do the work that are claimed, and then we would patent, say, a formulation or a concoction that contains these compounds that are, and the use of it for a particular disease that will be new. Okay, so you may find traditionally it's used for, let's say, for urinal, or let's say for headaches. Okay, and we will find a way of saying that by extracting it in this way, manufacturing it in that way, you will get these ingredients, and then it's useful for inflammation of the, or something like that. So there are ways around that. Okay, I think that's all from my side. I hope everybody heard me, and if there are any questions, I'm happy to take them now.
Thanks so much for that, Fani. Yeah, and I'll open up for questions. Any questions from the floor?
Deepak, I've got a question online which asks, how is ownership of interventions by employees determined? Specifically, if we had to go back to the case of Vodacom, please call me, and Nkosana Makate.
So I can talk about our experience. All companies and even universities these days will have, when you're registered as a student, or if you start employment at a company, the first thing you do is you sign away all your IP rights to the company. That means if you work at the company, all inventions that you make belongs to the company, and you have no rights to it, except for benefit sharing under the some of the existing IPR acts and so on. You may get some benefit sharing, but you have no rights to your IP while inventing it at a company. Even in small companies like myself, when I do an employment agreement, it will contain an IP clause that will say that the person working for the company during their time at the company, all IP will be owned and will be assigned to the company that they work for. So that's why, in the case of that, legally speaking, from my point of view, Vodacom owned the rights. So I presume Vodacom would have had a employment agreement like that in place.
Thanks, Fani. A second question that came in is, you stated that getting patents often differs regionally. What do you think is the easiest process to get an IP administered around the world for a company that wants to get the product global?
So it's very difficult. So I mean, the classical route we used to take is by filing a provisional patent in South Africa. For starters, it's not examined, it's not published. After 12 months, if we see we have enough data to actually go for a full PCT, we file a PCT, otherwise we'll lapse it. But then a PCT is a patent filed in Europe, typically one of the European patent offices, France or somewhere like that. It gets examined by the European Patent Office. You get a very good idea of whether or not the patent will be granted in Europe, at least. Okay, if you get a negative IPRP that tells you that you're not inventive, you're not novel, and so on, you're almost guaranteed not to get a patent in Europe. But it doesn't necessarily exclude you elsewhere, although there are many territories that will just look at the European outcome and will accordingly give you the similar outcome. But the USA, of course, do their own examination, and I've often had a very easy grant in Europe and then get to the US and it's a complete nightmare. But the US, at least, is reasonable. You can actually argue your way through. You may get a very different patent granted in the end of the day, but you will get one granted there. What I did find very, very, very difficult is getting patents granted in China and India. Australia, Brazil, I could say South Korea, people like places like that, Aripo also doesn't examine really. But I mean, Australia does examine, Brazil also does examine. Getting patents there are reasonably easy. If you get a US and a European patent, in all likelihood, between those two patents, you get something that will be grantable in those countries. In the Chinese case, it is extremely difficult. They are, for one thing, they are focusing very much on the unity of invention thing and narrowing it down to something that's almost not worth patenting. It'll be such a small aspect of the invention that ultimately having that patented doesn't really help you. So one thing. I find the same way in India. India, they often decline. You go to examine, you have to pay fees all the way along. Then they will go, the lawyers there will go and present you at the examiner's office to try and in the end, when you think all is lost, somehow by miracle or by crook, they grant it. I don't know why. The Chinese are very difficult. They tend to find prior art, or they come up with prior art that are in Chinese. It may be a little abstract of a conference in China, North China, somewhere dark, where you never even know existed. There will be a one-page abstract, and they will say that's prior art. We had a case like that for a microwave pasteurizer. It was literally a half a page abstract for a conference that nobody knows about in Chinese. Luckily, they had a graph as well. And in the graph, you could see the line, the temperature heating profile on the graph was very different to ours. And we argued that differential heating profile that we had as the differentiating factor. And after a lot of money, it was finally granted. But I, at some point in time, decided that trying to patent in China is almost like not worthwhile, but that's just a view I have. So it's very difficult. Europe and USA is straightforward, and many other countries, Australia and so on, but not those. China and India are very difficult.
Thanks, Fani. There's another question that's come in. When you think of the growing gig economy and how easy it is for people to share ideas online and such.
Yeah, I mean, that's the whole thing about in biotech, is people say, let's not patent, okay, let's just open, collaborate, and so on. And I think, I mean, there's merit in that. There's merit in that until somebody makes lots of money and somebody is not making the money, then the arguments start. I mean, the whole thing about CRISPR, the CRISPR technology, nice collaboration. I think it was Harvard and UCL in California. They did all the work done on the CRISPR technology. And ultimately, when the patent filed and started making money, it ended up with a huge lawsuits. Okay, so it's good for small companies. We do it all the time. We collaborate, we trust, we work on trust. But at some point in time, your key inventions you have to own. I hope it answers the question.
Yeah, thanks. Thanks, Fani.
Sorry, Fani, I got cut off there when I was asking the question. When you think of the growing gig economy and how easy it is for people to share ideas online and such, how does ownership of a patent get determined? How do I prove that something I published online belongs to me? Maybe, for example, a meme, a song, or a video. Is this a lengthy process? That was
once you publish it online, of course, it's in public domain. It's no longer patentable. So that's an easy answer to that one. In order for it to be patentable, it must be completely novel. It must not be in any document. You mustn't be able to find it online. It must be completely owned by yourself. So as soon as you start sharing things online, it is no longer patentable.
Thanks. That's it.
Thanks for that, Fani. So, Fani, I just want to ask one last question before we can move into the panel discussion. Just listening to the thread around IP protection and policing it, it reminds me of a case when we were at the CSR around the Hoodia patents. Maybe you want to just give an example of, at that time, I think it was Phytofarm that was licensed the technology, but we would see a lot of Hoodia-based products in the market, but they were never taken to task. And maybe the thinking around why they weren't taken to task would set some insights.
Yeah. So yeah, that's a very interesting case, the Hoodia example. So the CSR partnered with Phytofarm and Pfizer at the time to develop a therapeutic drug for obesity management or appetite suppressant management. They filed quite a large, the biggest suite of patents I've ever seen in South Africa, I'd say, around the world. It was supported by money from Phytofarm and some venture capitalists. So the patenting strategy was quite sound, and it was to enable Pfizer to do clinical trials and take the product through to a therapeutic prescription medicine, basically. At the same time, as soon as the patent was published, people started looking at it and copying it, doing Hoodia extracts. Some products actually did not. At the time, the CSI would go around, buy the Hoodia products that were on the shelves that claim weight loss and so forth, and to find that it didn't even contain Hoodia. It just had the name Hoodia on there. At some point in time, Hoodia, the word Hoodia was the biggest trademarked used name in the USA of all products, basically. Okay, so the Hoodia, the trademark Hoodia is even to this day well known in the USA. So despite the patent that was in force in the USA and everywhere else, some people became millionaires out of Hoodia, selling dietary supplements over the counter, ignoring the patent, small companies. And the CSR and Phytofarm and Pfizer at the time said, listen, guys, we're not going to go after the small guys because it's going to be a multi-million-dollar court case, okay, in order to prove infringement. And it would have worked, but let's wait for a big company to actually infringe, and then we make an example of those. So, of course, all the companies that were involved were smaller companies, and they never found the example of the one company to actually take to court, I think, is the answer to that question, okay, because of the expense of litigation, really, compared to even if you win the litigation, you want to get an award by the court that will cover your litigation costs and more. Otherwise, what's the point of spending the litigation? So the very sad fact of the matter is that by the time the Hoodia patents were returned to the CSR and the whole technology commercialization stopped, I think of all the people out there, the CSR made the least money. And the guys that were selling the illegal Hoodia on the streets and everywhere else made much more money. So it shows you that if I had to do it again myself, I would say, let's forget about a patent. Okay, let's just carry on with doing exactly what the other guys were doing and say, let's find a trademark, protect Hoodia, name Hoodia as a advertiser precedent, and then you would have been able to build a Coca-Cola type trademark around the world. So that's my view, personal view, of course, but that's my view.
Thanks for that, Fani. Brendan, if you can come up and then we can start with the panel discussion. So we're a little bit ahead of time, so it gives us a little bit more wiggle room to discuss key topics. And please, if there's questions online, please post it. And during the discussion, please raise your hands if you have any questions that you want to pose to the panel. So I introduced Brendan at the start of the event. So Brendan is the director at CiTi as well as BioCiTi. He's a lawyer. He's also a serial entrepreneur that has started many different businesses. And he's going to lead this conversation. And I'll hand over to him, and I'll take my seat there as well.
Great, thanks Deepak, and lovely to be with everyone today. And Rory joining us for the panel discussion, and Fani is still with us online. So hopefully we can do this conversation quite productively and also take further questions from the audience and the online audience as well. It was very interesting to hear two questions raised today about the Vodacom McCarthy case. And I think it's indicative of a case that sort of captured some of the public imagination, which often happens when legal cases tend to involve a David versus Goliath type story, where it's a very relatable story for members of the public to read in the media. And a lot of the message often gets simplified in the media coverage of those types of cases, whereas intellectual property law and patent law in particular is a very technically complex field. And I think it's just worth commenting a little bit on this sort of David versus Goliath and patent systems, because ultimately when you are looking to register intellectual property, you are in a sense looking to create a regulated monopoly for yourself over the use of a particular asset. That's not necessarily a bad thing. It can be to protect your brand reputation, or it can be to exploit your inventions. In the case of McCarthy, I think if you do read the court documents and do a detailed analysis of it, I think you see the point that Rory was making, which is that the case turned into a contractual case, not really an IP case, because I think there were communications between McCarthy and his managers in which they gave undertakings to enter into discussions with him about making some form of compensation to him over and above his normal compensation, without much detail to that. And that became a subject of debate as to what the reasonable compensation should be. And I think the courts found that Vodacom had a duty to enter into good faith conversations with him, having given him that undertaking. But at the same time, the court's not wanting to get too involved in that conversation, because how does one actually compute what reasonable compensation would be for an employee who's a product manager who's come up with a new idea? So it's very difficult to sort of sometimes separate out the very complex legal issues from the public reporting of that. But it is a big theme that I think we need to consider, that when you are looking to create effectively a regulated monopoly for yourself, you are the ticket to the dance, which Fani referred to, is very much a capitalist system dance. And sort of those rules to be used and enforced require quite a lot of capital sometimes. I think that's the message that we're getting from our speakers today. So, you know, you have to tread quite carefully when you step into this domain and understand, you know, how does a startup in particular, and at CiTi we work with a lot of startups, and BioCiTi working with biotech startups, bridge that gap between being a company that maybe doesn't have a lot of access to capital, but has some great ideas and wants to protect those ideas. So I think if I can open the conversation to my panelists just to discuss maybe a few practical ways that really startups can address this chasm as it was described before they're well funded. Are there some practical tips that you can suggest to really try to get maximized intellectual property protection early on at the lowest possible cost that doesn't necessarily prejudice you in the longer term?
Yeah, I mean, it is difficult. It is expensive, and especially for startups. So, as Fani mentioned, and as I also mentioned, if you can use trade secrets and other forms, trademarks, that is one way to go. Also, it's worth bearing in mind that a lead time in the market, 2 years lead time over your competitors, is very valuable, sometimes more valuable than a patent. So you've established the brand, Google is your search engine, and you might have 70% of the market, and that's based on your lead time in the market, your trademark. So that's another way to go. And then, as I mentioned as well, there are entities that are there to assist. Sometimes it's difficult with the state entities because it's public money. There's quite a lot of hurdles that you have to get over in order to access the public funding, and sometimes the admin and the time taken makes it difficult. But there's no surefire, quick solution to any of this, and it's an area that needs attention, and we're working on it. We need mentors, really, and so there are at some of the universities now, the tech transfer officers, they are setting up programs where asking business owners to mentor new startups and assist them. And IP firms are not always the place to find this information because we're involved in the protection of IP, but the whole ballpark of commercialization is another field, and it has its own challenges. But yeah, I mean, just be aware of what IP you have. See if you can get protection by trade secrets. Look at trademarks. Register designs. If your product has a shape or appearance which appeals, it's an inexpensive form of protection, and it's easy to enforce. It's quick to obtain. So that's another option. Patents take years to obtain, they're expensive, and it's hard to litigate on them as well. It's expensive. But again, they do have all those advantages if you do have the budget that I mentioned, all the credibility advantages, the stamp of approval, the bargaining power, and others. All right, but I don't know if Fani has anything to add.
Fani, you want to add anything there?
No, I think you captured it very well. I mean, it's that sort of mix that you have to get right. Depending on your own budget and your own commercial objectives, I think is the issue. Okay, so and it can be very personalized for companies. It depends on what your main objective is. Okay, I mean, if fundraising is your objective, I think a patent is a must. Okay, people are not going to invest lots of money into something that can't give you exclusivity. So, but then your objective would be to find a commercial partner with deep pockets that can carry the patent beyond the first 5 years, I think. So I think you're very much right in what you say. Those are really the crux of the issue.
Just to pick up on the Vodacom discussion. So maybe not fully aware of the case, but what is the key reason to the discrepancy at the moment? Is it because Vodacom did not have an IP policy in place for their staff, or what caused the situation that has come to pass now?
Yeah, I mean, I actually haven't followed it closely because it's been so many years in the running and it's changed in different courts. But typically, as Fani pointed out, in the modern era, if you join a company, you start at university, you sign away your IP rights. Now, I don't know if that happened in this case, and possibly that's one of the reasons for the issue. But also there's the matter of the fact that there was an undertaking given by management to reward Makate. But that just actually goes to show the importance of, as a business, putting in place your employment contracts with IP clauses, making sure that your employees, even subcontractors, developers, transfer or assign their rights to the IP to your company. And a particular area to look at here is software development, app development for your company, because often the software developers, they like to keep rights to some of the code, the software, so that they can use it in future projects, or they're using public domain software. So it's a bit of a minefield, but there you need to make sure that your developers assign the rights as far as possible to you, and not just license them, because if they're licensing you the rights, that means they're retaining ownership. So you would need to try to get ownership of that software. And of course, software is such an important field now for any business, and apps and so on. Barney, I don't know if you...
Yeah, I also think when people easily these days sign non-confidential disclosure agreements, and they think they're covered by everything. Often the disclosure agreements are too broad. Let's say, you'll say, for example, but we are in biotech business, or we are in pharmaceutical business, for example. It's too broad, and you have to, if somebody infringes on your confidentiality agreement, you have to prove to have received the information in confidence, and they use that exact information. So even if I sign an NDA, I would not share all of my knowledge immediately. And also the way you share it, you mark your documents that you send under an NDA with confidential in red all over it. So it's very clear that particular document is subject to that confidentiality agreement, for example. Okay, so, and you ask at the end of the, when your relationship fails, you ask for all documentation back, at least in writing, so you have proof that, so people don't manage their confidentiality agreements properly. I mean, signing one is one aspect, but afterwards, if you are infringed, to get people to understand that you have given information in confidence, I think that's one thing. Okay, so it's very important in biotech to keep some of the information confidential to the company only, really, and not share it with everybody that you meet and discuss.
Yeah. There's a question from the audience there, if we can take the microphone. It would be great if you could just mention where you're from and your interest in this event as you ask your question.
Hi, thanks. My name is Andre Fourie. I previously had an IT company. I'm now involved in hydroponics. On the software side, I mean, is it worth even trying to protect your software? I mean, what do you protect? The code? Or do you protect the functionality of the software? Because if you change, I don't know what the percentage is, 10 or 15 or 20% of the code, I mean, it's not the original code. So it's not protected anymore. It's always been, in my mind, an extremely gray area to protect code. And I even think it's impossible. So your thoughts on that, please.
Rory, do you want to take that? Yeah.
Yeah, actually, software is very well protected, not as software per se, not as the code, because that is protected via copyright, but as you point out, somebody could develop their own code doing the same thing, and then it wouldn't be covered by copyright. But the way it's protected is as a system with steps or modules for achieving a result. So you're not protecting the software per se, it's a computer implemented invention or system, and you're protecting the way that the process, the algorithm, the steps, the modules work together to achieve a result. Now, you can't just convert a known way of doing something on paper to typically, if you convert that, if you computerize it, that may not be protectable. But if there's something, again, new and not obvious, something clever, unexpected, unconventional, about the way that you're implementing this algorithm or this process on the computer, then it's protectable. You also protect the media. You protect the media that contains the program or the signal. I mean, these days everything is downloaded, so the days of protecting a floppy disk with the program on it are gone, but there are ways in which you can protect software, definitely. In South Africa, the Patents Act actually states that software, a computer program is not an invention, but it's narrowly construed. So as I point out, even though that's in the Patents Act, you protect it in different ways, not as software per se. So, I mean, my understanding is Microsoft have thousands of patents in South Africa. They haven't been examined really by the courts, but certainly in the USA, Europe, it's very common these days. And I don't know if you recently saw that South Africa, the Patent Office in South Africa granted a patent for an invention where the inventor was cited as an artificial intelligence program called DABUS or DABUS. So that's another area that's growing. What happens now when inventions are made by artificial intelligence? How's that going to be handled? Anyway, that's my contribution. Fani?
No, I think you're more knowledgeable in that area than I am, so I think I'm going to stay out of this one.
Worthwhile also remembering to try wherever you can to encrypt your code and not give people access to actually read and see and copy your code, particularly if you're exposing yourself to code audits, quality assurance audits, things like that. Make sure those agreements are very tight when you do give people access to your code. There's a lot of interesting cases involving copyright infringement where people have sort of taken elements of an original work of authorship and use those elements in a new application, such as a song or a new piece of computer code. And I think there sometimes does come down to an evaluation of how much work has been taken and copied. So if you took someone's sort of 3 years worth of authorship and just changed 5 lines of code, it would very much be a substantial infringement of the work. There have been some very high-profile cases, again, that caught the public attention with music sampling in particular, where, I think there have been some songs where Marvin Gaye's descendants, who are the sort of beneficiaries of his estate, have managed to sue modern musical artists for sampling very old Marvin Gaye tracks in modern songs just for a few seconds, and winning royalties from those types of cases. I am representing CiTi Impact Investments today, which is a special arm of CiTi who sort of seeded BioCiTi as an initiative. And when we look to see if a startup is investment ready, one of the questions that we will definitely look at is to see, is there some understanding of intellectual property in the business that demonstrates that it might be capable of raising investment. And something that I think it was probably both Rory and Fani mentioned is don't give all your disclosures in one go. A lot of venture capitalists and investors will refuse to sign a non-disclosure agreement with you in their first or before their first meeting. You'll often find, if you go to a sort of a big VC website, they'll be saying, we don't sign non-disclosure agreements because we get so many applications and we can't possibly sign all these agreements all the time. But then really what you're doing is that ticket to the dance. But it's sort of your first disclosures that hold something back and piques their interest. So your initial pitch deck, you wouldn't be putting all of your IP into those initial disclosures. You'd be talking about your industry, your niche within the industry, some of your business plans, some of your sort of revenue potentials. And once you've got some interest there, when they get much more interested in what you are doing, they'll probably want to do a much deeper due diligence investigation into any IP that you might be representing that you own. And a due diligence investigation at a later stage should definitely be covered with confidentiality agreements around all sorts of pieces of information that are confidential about your business, including your intellectual property. So the advice to sort of do it in stages rather than exhibit everything you've got at the first meeting is very practical sort of way to approach that. Yajna, have you got some questions coming through online?
Thanks, Brendan. So the first question is, and just bearing in mind that we have a range of viewers who are watching, what are the differences between copyright and trademark protection? And then I'll ask the second question.
Thanks, Yajna and Brendan. So copyright is there to protect direct copying of a work. It can be literary works, musical works, art, even computer programs. So it's a narrow form of protection because you actually have to copy. You theoretically would have to have the original document, let's say, sort of at hand, at your shoulder, and you're copying it. It protects works. Trademarks protects unique marks, brand names, stylistic representations. It can also protect even sounds in some cases, like the sound of the Harley-Davidson engine might be a trademark. But the point is, with a trademark, it's a unique mark capable of somehow being reduced to a graphical representation, but it's to distinguish the goods and services of a trader from their competitor's goods and service, or from their competitor. So they're different. As I say, copyright is to protect against copying of works, and trademarks are to distinguish your product or service from those of your competitors.
Can I ask you, Roy, to go a little deeper on some of that with copyright versus registered forms of intellectual property? So I think if you can just assist the audience in understanding when copyright can be asserted compared to other forms of registered property, and maybe a little bit of information about the difference between a common law trademark and a registered trademark, that if you haven't invested in the registration process, you may still have some form of trademark protection.
Yeah. One of the big advantages of copyright is that you don't have to register it. You can in the USA, but it's optional. So you automatically get copyright protection when you reduce your work to tangible form. So you write a book, you make a piece of music, automatically you get copyright protection. So that is a big advantage. Trademarks, as Brendan was saying, you can divide them into unregistered rights and registered rights. So again, you do get trademark protection without registering it, but you then have to have developed a reputation over time so that people associate your trademark with your product or company. So the big advantage of filing an application for registering a trademark is that it's, as soon as you've got your number and your filing number from the trademark office, it's prima facie evidence that the trademark is in place and that you have rights to that trademark. So it's really advantageous to file for a trademark. The other point is that if you don't file and someone else starts using your trademark, you then have to, there's a big evidentiary burden. You go to court and you then have to bring evidence that you had a reputation established by that mark, that the mark is linked to your company. You have to have witnesses from the public, expert witnesses. And all of that is done away with if you just register your trademark at the trademarks office. And it's relatively inexpensive. Couple of £1,000 to file, a few more thousand to register it in about 18 months to deal with office actions from the trademarks office. But compared to patenting, even design protection, you get good bang for your buck on trademark applications. Yeah.
Thanks, Rory.
Sure.
And a practical reminder to put that little C symbol and the year of the work of authorship after a work that you want to assert copyright over. I think with the common law trademark in South Africa, we do the TM symbol for asserting a common law trademark, and the R symbol is what you can use when you've been granted a registered trademark. There's some more questions coming in online. I'll come to you in a second, Yaj. There's one more point that before I forgot it, I wanted to make sure we spoke a little bit more about. There was a question asked from the audience earlier about sort of selecting your, I think it was your 10 top markets when you apply for a patent, maybe in one jurisdiction, and listing the other 10. That was an interesting point. Can I ask for a bit more information on how that part of the patent registration system can work, and particularly if you filed in South Africa first or another jurisdiction first, and then went to springboard from one to the other? How does that all work?
Yeah, so typically you would start with a provisional application that gives you 12 months of protection. Then often what people do, they get another 18 months protection through what's called a Patent Cooperation Treaty, or PCT application. Then you have to decide where are you going to file, which national countries, which regional areas do you want protection. And it gets very expensive. Now you're dealing with not only official fees, you're dealing with patent attorneys in each of those countries charging in dollars and pounds. So it's very seldom that companies can afford to or want to file everywhere. I mean, I've never heard of a company filing in every jurisdiction in the world. So you would need to narrow down your selection. So generally you look for where you get the most value for your money spent. So Europe, one patent application covers, I think, 27, 29 countries. USA, big market. So those are often your first go-to territories. And not only must you look at where the market is, where the product will be sold or the process will be used, you must look also at where the product will be manufactured. So in the modern era, often that means China. So, it's where your product will be sold and then where your product will be manufactured. And then you can block both routes. But again, it's territorial. So if you don't file in South Africa, I mean, if you start in South Africa but you don't file an application in Zambia, then in Zambia people are free to practice the invention. There's nothing to stop them, except if you had a trademark there, for example. But yeah, it's a difficult decision. What you can do is, just simple searches online. You could, for example, if you have an invention in the oil industry, you can do searches. What are the top 10 oil producing countries? Where are the markets for oil products? And do it that way. But again, you as the business owner will know better than the patent attorneys where it's important for you to file. Fani, do you have anything else on that?
You're right. I mean, it's also a cost thing. So the choice of where you file, and there's also cost involved in translation of the patent in the languages of the country you're filing in, for example. So it can get very, very expensive very quickly. And the idea of markets, look at the major markets, I think is the answer. Manufacturing, exactly what you said. So I think that is the consideration for where you file. But I mean, you have to upfront think about it. I mean, I have had cases where we filed everywhere, and afterwards, our only competitor emerges in Australia where we haven't filed. So it can happen as well.
Yash, can I get a few more questions from the audience?
Sure. Thanks, Brendan. So this is the last question. How much does it cost to register intellectual property, be it music or product design? Is there a framework document?
Rory, do you want to have a go at that, and maybe also distinguish there's government costs, but then there's your service provider costs as well, and those can vary quite greatly.
Yeah, okay, so for music you automatically get copyright protection, for example. That you don't pay for that, you automatically get it. Again, as Brendan said, you would want to put your copyright notice on the music. But when it comes to registered IP, yes, you have to pay the government fees, the official fees. They are often not excessive, but where it gets expensive is paying the IP attorneys, and because there's a lot of work involved in drafting a patent application, and there's risk attached to it, it's liability, so it's expensive. The patent attorneys are expensive because of their training and the time put into the application. So, just for a provisional application, you could be looking anywhere between 20,000 to 40,000 rand, just ballpark there. Trademarks filing maybe up to 5,000, 2 to 5,000, something like that. So it's not cheap. And then, as I say, once you get to filing in the foreign countries, then you can be looking at 60,000 to file in the States, 100,000 to file in Europe. This is just filing. Then you have to respond to the examiners at the patent office via the patent attorneys. So you really have to, with IP, you must weigh up what is the potential commercial benefit, and you compare that to the costs of the patent program. And obviously, if the money that you stand to make out of an invention is going to be less even than the cost of obtaining protection, that's not a good business decision to go that route. But it all just depends on your market. And then if you get to, trying to enforce a patent, then it's, even in South Africa, you're probably looking at R1 million just to kick off on litigation to sue someone. Not many patents go to court, but the advantage, as I mentioned, is deterrence is a big one. A company, if they see you've got a patent, they'd rather just go and play in a different field, rather than potentially get bogged down in disputes and so on. So there is value. The patent system is just growing and growing. There are 3 million patent applications filed worldwide every year, 300,000 a year just in the USA. At any one time, there are about 12 million patents in force, and patents only last for 20 years. So, and it just grows. It grows every year. So there's clearly benefit. Otherwise, companies wouldn't be involved. But you need to be at a certain level to make it financially viable, or you at least need to work out what the commercial benefit is going to be and whether that covers the patent program. Thank you. Fani?
Yeah, no, I think you're right. Yeah, the cost, like I say, we just looked at a ballpark figure at the time of 2 million rand per patent, and that's without litigation. They're just paying. We would not file. We would file a few European countries, USA, maybe one or two other countries, not too much. Okay, but ultimately we won't spend more than about 2 million over the time. But you're still losing out on certain territories and so forth. So I think it's a very costly exercise. And for a small company, what one does is actually try and postpone as long as you can. You can accelerate your patent prosecution, for example, by requesting IPRPs and so on from the offices. You won't do that normally as a small company. You would like to postpone it, hoping that you get an investor that can, or a licensee, or whatever it may be, that can actually carry the cost going forward. But very few companies can handle the patent cost beyond, let's say, the first 5 years. Up to 5 years, you can still maybe handle it, then you get international filings and any kind of litigation, and you will run out of money very soon. So for a small company, you must really think very carefully about patenting. But I said that there are companies that have a platform technology looking for venture capital investments, and then you have to patent. Okay, if you're looking for a USA company to invest into your company, if you have no protection, you don't even have a meeting with those guys. So it's really depending on your business and what you do.
Just 2 questions, please. As small businesses, these costs we're talking about here are very huge, like they're saying them. Thank you. Would you say these processes, like your trademark, your trade designs, are they mutually exclusive from patents? Can you do one without going through patent? And following on that, if you had a trademark, for example, on a product or a design, could you take that maybe to if you need a partner to in your what you're doing, could you take that to them and use that as a protection for yourself, for your design, that kind of thing?
Yeah, so I mean, absolutely, these are individual rights. You don't have to trademark if you patent, or you don't have to patent if you trademark. And then, so the trademark is often a very important and less expensive way to protect your IP, or even trade secrets, keep it secret if you can. But that's risky because one employee could go and disclose, as Fani was talking about, and then you've lost your rights. We've actually got my colleague Rechard up there. He's a trademark expert. I won't put him on the spot, but he's the guy to talk to, Rechard, afterwards if you're interested in trademarks. And then I didn't quite understand your last point, but you were saying if you go to a partner.
If you maybe needed a partner to help you on a design that you've got that you want to bring onto the market, you went to one of the big companies in South Africa, they might steal you. So could you use a trademark or whatever trade secret document as protection for yourself?
Well, that would be the purpose of the non-disclosure agreement, the NDA. And that's, it's got its risks, but in the end, if you need a partner, financial backing, you need to do that. But you need to protect it to keep it confidential, because if you don't, and then you won't be able to get a patent after that if you just disclose it. So you go to these partners. Look, it happens. I explained that situation that one of my new clients had. But if it's a reputable company, the larger companies, it's unlikely to happen. I mean, it would be so bad for their reputation and business. It's just not the way business is done. But you do what you can. You put in place the NDA, and obviously limit who you talk to. You don't, you try to limit the disclosure as far as possible. But if you can file a patent application first, that's first prize. If you have the money, file a provisional patent application, because then from the day that you filed that application at the patent office, you are then protected, even if you disclose your invention publicly, provided you carry on with your patent program. So that's first prize, get a provisional application. And there the costs are not as high. I mean, if it turns out that it's got commercial potential and then you get a partner on board and they've got the financial backing, then they can pay for these patent applications overseas, down the line. So it's often done that way. You would get a backer, a partner, to assist you with your patent program.
I think we've probably run out of time now. We're going to wrap up shortly. I'm just going to comment on this last question as well, because self-funded startups who are sort of bootstrapping their way into their business is something that we've been working with at CiTi for more than 20 years, and we know the journey. It's not an easy journey, but it's not an impossible journey either. And if I can give the 90-second summary of what I think a bootstrapped, self-funded startup should do, it's to try to save up some money on the side. Maybe it's 20,000 Rand by sort of working at your core job, get a little bit of money on the side, create a name for your business, maybe just register some domain names to start with. They only cost a couple $100, a few different varieties of your domain name, which is sort of putting something out there. Read up as much as you can on different forms of intellectual property. Get yourself a reasonable non-disclosure agreement. You can download those sort of free templates from the internet. They're not perfect when you use a free download. I always warn people against using template legal agreements. But maybe a little bit of that money you've saved can be for one consultation with a lawyer who can give you a bit of advice. Apply to programs such as the small enterprise programs run by organizations like CiTi, where you can get assigned a mentor who can try and help you through some of these early stage questions. Apply for grant funding that can sometimes be used for intellectual property development. Get a little bit of that money together. If you are talking about patents, do not try to file a patent on your own. That is just, in my opinion, slightly too technical and too specialized, but you can get your first consultation in with a lawyer who can start to give you a steer. So I think doing it in stages is the way to go. It's not impossible. And I'd encourage everyone, though, to make sure that they sort of taking the advice that they can afford to take as early as they can take it in those stages. On that note, I'm going to suggest that we thank the audience for attending, including the online audience. Thank you, everyone who's sort of connected in to attend this event. For everyone who's here, we've got a few snacks and drinks to serve afterwards. I'm going to thank Rory and Fani very much for your participation, giving of your time this morning. Deepak, thank you very much for sort of convening the event and really being the energy behind bringing this event to the audience today, representing BioCiTi. Yajna and the city team for sort of producing the event. And Deepak, I'll hand the mic to you just to say some sort of concluding remarks, and then we can break, I think, for a snack.
Thanks for that, Brendan. And thanks to all of you for attending. I think the response was quite a bit, which shows the importance of this topic. And I hope that through our esteemed speakers, we've managed to help you understand a little bit more on intellectual property. My key takeaways from this event that I think each entrepreneur and startup should think about is your IP protection strategy, if there is any, and know that up front. So because that dictates how you put out information, how you do marketing. If you intend to patent, then you need to think very carefully on how you roll out that information, because you might lock you out. Consider the other options to patenting, like trademarks and trade secrets. But I think it's important to have that strategy up front, but also as a business have an IP policy so that your staff are sufficiently incentivized to create new ideas, and upfront how the intellectual property they bring to the table is shared and protected within the organization. So, we spoke about ceding your intellectual property to the business. That was the case, with us at CSR, is that we ceded it, but the government, the policy of the company was to give us a part of it back. So I still get royalty checks every year for some of the technology. So it's a responsible thing to do in the long term, but it's also a way to protect your staff and to keep them sufficiently incentivized. So with that last closing thoughts, I'd like to thank everybody, and thank you, Fani and Rory, for your time. It's a valuable time. So thank you again. Thanks. Please, help yourself to